A very good afternoon. Thanks for staying with us here on Breaking Ground. This afternoon, we get you non-stop details we're tracking. I'm Kritsween Walia, and first up, we start with the latest in the Gyanvapi case. Now, remember, the Supreme Court has taken up the Gyanvapi case and was hearing the Masjid Committee's petition challenging the commission survey of the mosque ordered by the Varanasi court. Now, the Supreme Court has said it will wait for the order on maintainability aspect. Justice Chandrachud saying that further hearing of this proceeding will take place after the hearing in the maintainability aspect is completed. So that's the big breaking news coming in. And Harish continues to stay on with us as we keep up with those main points and what the court has observed. The Supreme Court has refused to hear the Shivling worship plea. Harish, what more can you tell us of the observations you're picking up?
Significant development because remember the last date of hearing, Supreme Court had directed the district judge Varanasi to hear and decide on a priority basis first the petition filed by 5 women devotees who had sought daily worship of the murals and idols engraved on the western wall of the Gyanvapi Mosque, and only after the maintainability issue is decided and the other issue could be gone into. So today, since the hearing is still on in the Varanasi court, the Supreme Court has said that it will wait for the outcome of the maintainability suit pending in the Varanasi court. In between, there were other 2 petitions also taken up. One which had sought worshipping rights of the Shivling, and another petition filed by Vishnu Jain and Harishankar Jain, who had sought a carbon dating of the Shivling which was recovered, and also a direction to the Kashi Vishwanath Trust to take possession of the Shivling which was recovered from the mosque. But on these 2 issues, Supreme Court has given the liberty to the petitioners to raise these issues in the Varanasi district judge court, which is at present seized of the matter. During the hearing, the Masjid side in fact argued that the advocate commissioner which had conducted this survey should not have been appointed, number 1. Number 2, the commission survey should not have been ordered. Number 3, it's like a fruit from a poisonous tree. Number 4, court had no jurisdiction to appoint a commission survey. The report should be struck off the record, and the Supreme Court must go into legality of order appointing a court commissioner and ordering survey. But Supreme Court has for the time being very clear that the commissioner report cannot be cited during the hearing of the maintainability suit, and directed all these petitioners to raise all these issues in the district judge Varanasi, which is at present hearing the matter. So as of now, the biggest takeaway is that Supreme Court has decided to wait for the outcome of the maintainability suit first before proceeding with the matter. Back to you.
So it says essentially that the Masjid side's petition cannot be entertained at this juncture, Harish, to speak of it in layman's language. Till the time the matter is in the Varanasi court and a word comes in from the Varanasi court on the maintainability aspect.
Yes, that is precisely the point. Remember, what is Supreme Court hearing? Supreme Court is hearing a petition filed by the Anjuman Intizamiya Masjid, which had challenged the appointment of advocate commissioner and ordering of a survey, and had in fact sought stay on the proceedings going on in before the Varanasi district judge, saying that first of all, this petition should not have been entertained itself, because it runs contrary to Places of Worship Act 1991, which had provided for a status quo of religious worship, places of religious as on 15th August 1947. So as of now, there is no relief for the Anjuman Intizamiya Masjid, that is the Masjid side, because Supreme Court has said that as of now we will not continue with the hearing of this petition till the Varanasi civil judge disposes of and comes out with the judgment on the maintainability suit.
All right. The bench also took up another PIL seeking carbon dating of the Shivling stated to be found in the Gyanvapi complex. Harish, what more can you tell us about this particular issue being raised in the court?
So after the hearing on this matter, 2 individual petitions were taken up. Number 1, one petition.
All right. 1 second, Harish. I'll come back to you in just a bit. We have Vishnu Jain joining us on the phone line. Mr. Vishnu Jain, now the court says in as many words that one cannot, from the Supreme Court, rule on this particular issue since the hearing in the maintainability aspect is still underway, and once it's completed is when will the Supreme Court intervene. What do you make? It's a big development coming in.
Yeah, I think it's an important observation by the Honorable Supreme Court, because the Supreme Court has made it very clear that let the first hearing on the maintainability of the issue be decided, and therefore we'll hear the appeal or the SLP filed by the Anjuman Intizamiya. So I think within 4 or 5 days, the hearing before the trial court, before the district judge Varanasi will be concluded. And then we'll proceed further in the matter. The Supreme Court has listed the case in October, in the month of October. So we'll await the judgment of the trial court and then we'll proceed further.
All right. And what happens till then? The status quo is maintained because, you know...
Till then the status quo will be maintained. The interim order of the Supreme Court is very clear, which was passed on 20th of May, that the sealing of the Wazoo area will continue till the time the Order 7 Rule 11 maintainability issue is decided by the district judge.
Okay, and the Supreme Court has made it very clear that they will not hear granting possession of Shivling to Kashi Vishwanath Trust will also not happen. So that is also an issue that the top court will not hear. The top court will not basically take up any of the issues that were listed before it till the matter is resolved in the Varanasi court or a word comes in from the Varanasi court.
Absolutely right. Till the time maintainability issue is decided, till that everything is halted. And once the trial court takes a view, then the matter will proceed further before the Honorable Supreme Court.
Mr. Jain, what about the carbon dating of the Shivling?
See, that petition for carbon dating which we had filed, we have withdrawn that petition because the Supreme Court observed that all these remedies are available before the trial court. So they have allowed us to withdraw the petition, and we'll move our applications before the Honorable Trial Court once the hearing of 7/11 is decided.
Our top court also said will not declare the survey null and void. So that's an important observation coming in from the top court. What do you make of it?